Good afternoon, everyone. It's a pleasure to have you with us today, and we are blessed to have Kristin Marshall with us from Canada-U.S. Border Clinic. We already had Kristin with us in the past talking about the process for people who would like to travel to Canada, to go to Canada from the U.S. border. And today we got Kristin with us again one more time. We are very, very blessed. Kristin, good afternoon. How are you doing?
Good afternoon, and it is a pleasure to be here with you, Emmanuel, and with the audience as well. My pleasure.
Oh, thank you so much. It's a blessing to have you. Last time there was a lot of demand for the interview we did, and people keep asking questions. Kind of we do part two interview, like what's new, because we did this interview very early in the process, and people are still panicking right now. So I was wondering, what do you have as like new situation, new information since our last interview?
Well, I do have new information, and I wish that it were better news to share, but I'm afraid that the update I have is one of really extreme caution, that I recommend people should get legal advice before they make an approach to the Canada-US border. And even if they do have a relative in Canada who would be eligible to serve as their anchor relative to enable them to come in to make a refugee claim here, the Canada Border Services Agency is looking very, very carefully at the documents people bring to show proof of their family relationship. So that's kind of point one, that it's really important to make sure you have good proof of these relationships. And the second point is that if somebody either does not meet an exception to the Safe Third Country Agreement, or if the Canada Border Agency is not satisfied with proof of family relationship, and the person is denied entry to Canada, they're found ineligible to make a refugee claim, then they're returned to the United States. And that's the other big. It used to be that we would say there was a chance of detention upon return to the United States, and now it's more like a likelihood. So getting legal advice and a review of these documents before crossing is more important than ever.
So you talk about exception, Kristin. What would be some of the exceptions? Can you please give us some examples?
Certainly. So the most common exception to the Safe Third Country Agreement between Canada and the US is if somebody has an eligible family member in Canada. And the list of family members that count are if somebody has a spouse. So this includes somebody who's married, a common law spouse, or a same-sex spouse, a parent, a child, a grandparent, a grandchild, a sibling, an aunt, an uncle, or a niece or a nephew. It does include half siblings. So if you have a brother and a sister who share one parent, but unfortunately, it does not include cousins, and nor does it include, say, a great aunt or uncle.
I've seen cases of people who have close relationship, like brothers and sisters, but there are problems in their birth certificates, things like that. The last name is written like differently, or there is a middle name that is not in one, and they are turned away for that. Do you know any example about that?
Yes, thank you, Emmanuel. That is also our experience, that people who do have an eligible family member in Canada, and just I should say for a moment what makes that family member eligible. So they have to be a Canadian citizen, a permanent resident, um, somebody who is over 18 who has made a refugee claim, um, somebody who has had an accepted refugee claim, or somebody who has had a humanitarian and compassionate application in Canada approved in principle. It's not enough to have made an H&C application, but they have to have it receive first stage approval from immigration. So if you have one of those relatives and they have one of those statuses, we have seen CBSA turn people back, as you say, because of misspellings in birth certificates. Sometimes the parent might have their, long name Bartholomew in one person's birth certificate, but the sibling who was born 10 years earlier might have it written as Bart. Anyway, that's a poor example, but you know what I mean. Something like this that shows an inconsistency or any cause for concern by CBSA can result in rejection at the border. We'd also seen, particularly for Haitian claimants, because of the kind of natural disaster of earthquakes and floods, some people's birth certificates may have been destroyed. So they applied for a replacement or proof from the National Archives in Haiti. And instead of getting a duplicate birth certificate, what they get is an extract from the National Archives that confirms their dates, birth certificate facts. If this is issued recently, the officer might have questions about what happened to the original document, why don't you have it, and how did you obtain this extract from the archives?
If someone is denying entry based on one of these problems, is there any way like they can reconsider? I'm not calling in appeal because they don't like have the right to be on the country yet, but is there any reconsideration before the agent could turn these people away, say like is there any exception, any reconsideration they can make?
Yes. Although I do have to say first, it's so much better to be prepared in advance and to try to get additional evidence to help prove that relationship. But we can talk about that in a moment. If somebody is facing the situation where they were denied entry because the CBSA didn't like the proof of their relationship, there is a discretionary application that can be made to the Canada Border Services Agency to ask them to reconsider a negative, a finding of ineligibility in these circumstances. And in that reconsideration, somebody can include new evidence that proves the relationship, but it is far better to take the time to gather that evidence. If you see in your own relationship documents that there are some misspellings or differences, it's better to deal with it before you try to come to the border than to try to correct it after. So there's two things you can do after a finding of ineligibility. One is to ask the Canada Border Services Agency to reconsider that decision if you can put in new evidence. And they do have a right to apply for judicial review at the federal court as well. But this is also kind of a cumbersome process that can take over a year. and it's very difficult to get a lawyer to help with these applications. Our office has just expanded our mandate. Mostly, we advise people about whether or not they are eligible under the Safe Third Country Agreement to come into Canada. We also talk to people like you or community workers about the law. We make these presentations, and we've just started offering some representation in limited cases where there have been what we think is mistaken decisions about eligibility, and to make these applications for reconsideration.
Say now, someone come to you, like Canada Border Clinic, and say they would like to cross the border. They need your help. I know we talked about that last time, but it's worth remembering and reminding them what will they do? What would you do? What is the process?
Okay. Well, we really like it when they contact us before they go to the border. Unfortunately, we can't speak to everybody who would like to come to the border. If they don't, we have to determine if they meet an exception to the Safe Third Country Agreement. And as I said, the most common one is if they have a family member in Canada. So in that situation, we would ask to see the individual's identity documents. We'd also ask to see their anchor relative information. We would meet with the individual who wants to come to the border, and we usually ask their relative to come to that meeting as well. If there are issues with the documents, then what we can do is ask the anchor relative. Perhaps they still have copies of the information, the application they made to Canada Immigration. Let's say somebody wants to come to the border and they have a brother who's a Canadian citizen. If that brother still has his application for permanent residence, we can ask him to get that and look and see if his brother was listed there. We also occasionally have done an affidavit, which is a sworn statement from the anchor relative that includes the identity documents. It can also include family photos that shows it places them both in Haiti at this time, and it identifies who are the other family members in the picture. And occasionally, if the documentation is very poor, and this can apply to people from many countries, doing a DNA test is a possibility to confirm that familial relationship. But this is something that is costly and is not accessible to everybody. So we would look very carefully at the documents, and if we think there needs to be some explanation, we would consider getting a sworn statement from the anchor or the migrant.
And then how long could this process take, like from start to end?
The process of consulting with our clinic?
Yes. So say I come to you, I would like to cross the border, and then I give all the documents, and you would have to contact my anchor relative in Canada. Before we start like closing everything so I can walk freely, how long would that take?
So, good question. We have what I would call a small but mighty team. We have just this week had a few law students that are helping us this summer. It can take a few weeks from the first call to our clinic before that person would meet with either myself, or we have a second lawyer on board with us too. It also depends how quickly our team, who does the intake, will ask the person for the documents, and there may be a little bit of back and forth as they collect the documents. But I would say from first point of contact with our clinic to consultation could take between 2 and 4 weeks. I wish it were faster and I wish we were bigger, but we're doing what we can.
Coming back to the family like relationship to be established, like for people who are family by adoption, like is there any consideration for that? So they might not have the same name, the same document, but they have adoption documents.
So we would want to look at the adoption documents. If there is something from a court legally proving that this person is adopting the other person, that is very helpful. What is sometimes more common is that family members or close friends may just take in a child without that legal process. And so the person is what we call de facto, like more or less, I raised this young girl, I treat her like my child. But if there isn't the legal adoption paperwork, that type of relationship is not recognized, unfortunately. But so we always want to look at the documentation. Yes.
They then say that someone meet all of these requirements, you clear them. Is it 100% certain they won't be turned away?
It is so difficult, Emmanuel. I mean, I think in the practice of law, I think people have to be very wary of any lawyer that would say anything is 100% certain. You know, we do our best to have people as prepared as possible, but how the individual border officer might treat their case, it's hard to predict. Similarly, I could have somebody with the best prepared case go to the refugee board, and you really can't account for the personality or sometimes, approach of decision makers. But we do our best to make sure nobody goes to the border unprepared. But when they are fully prepared, it doesn't guarantee success, but we give them our best, our best
So
advice on it.
is the process the same regardless of the border print? I know there's a very huge process on Buffalo, New York, but some of the border print, like if you go to Maine, you go to Vermont, they don't have that much security. Is the process the same everywhere?
Good question again. I think the Canada Border Services Agency officers are given the same training, but some more frequently used borders, there's a greater familiarity with the refugee claim process and the Safe Third Country Agreement eligibility. We did have a client at the end of last year who came to a very small port of entry in Vermont. And without going into details, it was clear that the officers there did not fully understand anyway, or maybe it was just an individual officer, but there is no best port of entry to go to, but a very small one, they may not be as familiar with the Safe Third Country Agreement or the kind of refugee claim eligibility and process. There is one port of entry at the Peace Bridge between Buffalo, New York, and Fort Erie, Ontario, where it is possible to make an appointment in advance of coming to the border. And there are supports at Vive and also the newcomer clinic, but the wait may be very long there because they are also super busy.
No, but I know, Kristin, they are like in Vermont. When I visit Vermont, there are Canadian who come to library in Vermont, and like people from Vermont to cross the border to go to the library or any other things in Canada. So there's no check. Say that I am able to go and sit at the library, or they don't check me. I went there, I spent like couple days or 2 weeks or 3 weeks. would that be a problem for me? And am I considered a Canadian resident? I'm not asking you like to speculate on things, but I know there are points that people can cross. They don't have any. There's no check, and they can go. Like in Vermont, I went to Canada several times and crossing the border, sitting at the library. Nobody asked me anything. Say that I'm able to do that. Is that something? What can you tell us about that?
Well, I can't tell you much. I mean, I just as a lawyer, I am bound by certain rules, and I can't speak about, crossing the border not at a legal port of entry place, because technically that is kind of uh, a breach of the law. Um, and I just think people have to be very careful right now. We had some clients. There is a park that may be similar to what you're talking about with that library in Vermont. There's a park out in British Columbia where people can visit from the U.S. side and the Canadian side, because the park it's accessible for both. But we had a client who ventured a little too close to the Canadian border, and Canada Border Services Agency were at the park, and they did apprehend those people. So there's always kind of a caution about being apprehended. But really, it's kind of beyond what I could speak about that.
But what is the law said for people crossing without being apprehended if they were able to prove they were in Canada for about like 2 weeks, 3 weeks? Will they be able to turn away like to the uh, U.S. Border Patrol?
So, yes, okay. When Canada extended the Safe Third Country Agreement to apply to the whole Canada-US border about 2 years ago in March 2023, no more was it possible to come through at places like Roxham Road. That is closed now, but there is a provision in the regulation that says if somebody is inside Canada and has been here for 14 days, then the Safe Third Country Agreement does not apply to them. Um, that is something that was added to the regulations 2 years ago, but technically I don't advise people to do it, but it is in the law.
Yes, so we're not advising people go cross the border and then spend 14 days, 15 days without being caught. But I know the law exists. Like there's this provision like for someone who is in Canada for 14 days, if they did not get caught, so they can have some special some special treatment. They can ask for refugee status.
Yeah, it's not special treatment. It just means um, if they can show that they've been in Canada for 14 days, they have proof, and that then the force of that law is that the Safe Third Country Agreement does not apply to them after 14 days. So if they never had a relative or they didn't meet a different exception and they are somehow in Canada, after 2 weeks, they could ask for protection.
Mm-hmm. How long can someone stay at the border if they meet all the requirements? So they have to go to screening process, all of this. Is it there's something that can take days? Like someone might stay for days until they are released to their family member, or just couple hours?
You know what? The first part of your question, I wasn't clear. Did you say how long does it take if somebody comes to the border?
Yes, so
Yeah.
they went to the border, they meet with an agent. How long it take? Is it someone who can spend like the day at the border or days or more than that?
Yeah, very good question. Um, we always advise people to like bring food and water. It is, I would say, quite common now that it can take as long as 24 hours and sometimes longer. Um, and if there's small children, you need to kind of be prepared for that as well. It can be very long. It can be more than a day. And the other really important thing that we say is that if the person has an anchor relative in Canada, we really recommend that that person come to the border from the Canadian side when their relative that they know when their relative is coming, where, and that they are present on the other side in case Canada Border Services Agency wants to speak with them to confirm the relationship. But having said that, Emmanuel, CBSA does not always talk to the anchor relative. So don't count on your relative bringing their ID to the border. The person coming to seek entry into Canada should have all the documents for themselves and for their anchor relative, because sometimes the border agent does not contact the relative, but even still, we recommend that it's a good idea for them to be there.
If the border agent contact the relative, they were not able to find them, would that be a reason to deny entry to the person who tried?
It could be, because if they're trying to confirm some aspect of the family relationship and the person's not available, I mean, they may wait an hour and try again, but I think it's really important that that not happen. I think I've heard of situations where somebody came to the border and the anchor relative was on vacation. And these days, because of the much higher risk of detention if returned to the United States, you can't take that chance. That person has to be prepared and available.
So, if the agent is going to deny someone, is it like they are denied on spot, or they can spend several days in detention in Canada before they are turned away to U.S. Border Patrol?
I have seen it take hours. I mean, sometimes there's just a lot of people waiting around to talk to an officer. And they're not so much detained in Canada as they're at the border, and sometimes they have to just sleep on a bench while they're waiting to talk to the officer. It is possible. So there was something important that I also wanted to talk to you about, and that is the category of people who have started a refugee claim in the United States, that this raises complications for their situation coming to the border to make a claim. And so if somebody has started a claim in the United States and the Canadian government has proof that they did this through the information sharing agreement between our countries, if they took their biometrics or their fingerprints, having made a claim in the US means that the person is not eligible to go to a refugee hearing at our refugee board in Canada. People who did make a claim in the US, they have an anchor relative in Canada that they can prove it. They can still come to the border and enter Canada, but they get a different type of risk application called a pre-removal risk assessment. And it's complicated. It's why, again, we'd like people to get legal advice first. But in the situation where somebody has made a claim in the US, they are not eligible to make a refugee claim here. They're only eligible for a pre-removal risk assessment.
But even if the US denied the refugee claim, they are still not qualified?
That's right. Yep. If they started it, if they didn't even go to a hearing, or if they went to a hearing and it was denied, it's all the same, that they only get this kind of other type of risk application called the PRA. But the most important part about that is that a PRA applicant, or somebody who is entitled to this pre-removal risk assessment cannot be an anchor relative for anybody. So here's an example that I hope will highlight. Say you have a husband and wife and a child in the US, and they did make a refugee claim in the US. The husband has a brother in Canada who's a Canadian citizen. Because the family made a claim in the US, the father is eligible to come into Canada for a pre-removal risk assessment. His daughter is eligible to come in for a pre-removal risk assessment because in the father's case, his brother, he can prove his relationship to his brother as a Canadian citizen, and the girl can prove her relationship to her uncle and his Canadian citizenship. What is heartbreaking is that the girl's mother and the man's wife are not connected to her brother-in-law. So the brother-in-law cannot be an anchor relative for this family's wife. So they have to make a very challenging decision. Should father and daughter come into Canada through the uncle or brother, or does the whole family not come in because the mother, the wife, unfortunately, doesn't meet an exception? And once the dad and daughter are allowed in through the uncle, they cannot be an anchor relative for the brother cannot be an anchor relative for his wife. If they had not made a claim in the US, he could.
Okay, so let me do a follow-up on. So say that I made a refugee claim in the US. I asked request for asylum, and now we understand a lot of cases are being denied in the US, and I didn't have any due process. They didn't do any full consideration of my case. I was denied. Would that be a reason for Canada to deny my request as well if I try to go and ask for refugee status in Canada?
Well, it's a good question. Canada does not get into the details of what happened in the United States. If you are found eligible to come into Canada to make a pre-removal risk assessment, then you could argue what happened in the US and why it wasn't a proper determination of the risk you faced in Haiti. But in that situation, the denial of justice in the US refugee process, that is not grounds itself to have somebody admitted. That person still needs to have an anchor relative in Canada in order to meet an exception to the Safe Third Country Agreement.
Okay, so if I have an anchor relative in Canada, so there's even if my case was denied, so I can still go if providing my anchor relative accept.
That's right. If you have good proof of your familial relationship and your anchor relative status, you can come in. But for people from Haiti in particular, or Venezuela or Afghanistan, there are certain countries that Canada does not remove people to. So even though the person with the claim in the US has an anchor relative, they're entitled to come into Canada because they're entitled to a pre-removal risk assessment. Because Canada's not removing people to Haiti, the government will not give them that application to say, here, you can fill out the pre-removal risk assessment. So they get to be in Canada. They are protected from removal to Haiti, kind of in a bit of a legal limbo. And the only way forward to get permanent status in Canada is something called a humanitarian and compassionate application, where they have to show that they face hardship if they go back to Haiti, but also that immigration wants to see if they're established in Canada. So that that takes a little while before they can make that type of application. So getting back to the situation of the little family, if father and daughter decide to come in because of their relationship to his brother, it will be many years, unfortunately, before they might get permanent resident status in Canada to be able to then sponsor the mother and wife.
So,
So,
another question, why is that when people are denied, so the agent, they turn them to the U.S. Immigration, so not directly sent to their original country. So they have to be, it has to be like that, like you give them to the U.S. Immigration, like ICE.
well, if somebody is found ineligible to make a claim, or they don't meet an exception to the Safe Third Country Agreement, Canada does return them back to the United States, and they're given something called an exclusion order. So that is an order that basically removes them from Canada, and that exclusion order is valid usually for 1 year. They go in to the custody of Customs and Border Protection in the US. So they may be detained there. And then the Customs and Border Protection can transfer them to ICE, which is the detention facility where they may be facing removal back to their country eventually. If somebody comes to the border and they don't meet an exception and they're returned to the US and they have not made a claim already in the United States, then it's very important that they make it known to any of the US authorities they're dealing with that they have a fear of returning to Haiti. But I'm not a US lawyer, and so I can't comment on those processes.
So there's another situation, Christine, about the relationship. If say that I have a girlfriend, so I know Canada recognize relationship of people who are not married, and we live together when we were in Haiti, and for some reason my girlfriend had a visa to go to Canada, and then I could not. I'm in the US now. Would that be considered like a relative situation if I can prove that we lived together in Haiti for a couple of years?
Um, it really depends on the situation and the proof that you have. And Canada Border Services Agency is very careful when they're looking at common law relationships like this. It also depends how long you've been separated, because looking at what constitutes a common law relationship is having lived together for a year. But it 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 depends, and you'd have to have good evidence, and it most often, or most likely in my experience, it's not enough that people just say they lived together. They really need proof, like documentary proof or a sworn statement from a relative or somebody who knows them as a couple. So that would be another thing that we would try to help advise people. The other thing is, if in that situation the girlfriend is free to come and go between Canada and the United States, and you can prove kind of the history of the relationship, it might make sense for people to get married, because that's one more proof of the relationship.
So I know we spoke a lot about the process. So what would you say the right thing to do, given all the explanation you gave? Like someone is watching right now, say they are considering crossing the border to Canada. Not unfortunately, you cannot take every single person because of limited resources. But what would you tell those people the right things to do, where to start?
Okay. Where to start is, I would say, go to our website, the Canada U.S. Rights website, and we have information for people who are wanting to cross the border. in English, French, Spanish, and Creole. And so first look at whether or not they meet an exception to the Safe Third Country Agreement and some of the other recommendations we have there that discuss, documents that you should collect to prove your relationships. Also, contact our clinic if you think, looking at the website, that you do meet an exception. So you have a family member here who has eligible status. Say that, and you can contact our clinic. You can share with them the info at canadaborderclinic.org email. And then we will do an intake and collect your documents, and that we offer to review the documents to give you our legal opinion if they're sufficient for you to enter, or whether we think that we recommend you get more evidence to prove that relationship. But advice before you approach the border is really important, in addition to all the things we've talked about.
Okay.
Yeah.
People in the U.S. now, like immigrants, they are different situation. For us Haitian, I know you are not a lawyer in the U.S., so you don't necessarily respond for the things related to immigration law to the U.S. Say
Right.
that like someone who has a temporary protected status, they don't make any legal claim here. They did not ask for asylum. So would that person consider not eligible because they didn't have any claim for asylum, for refugee claim here? They were admitted like under the Biden program, like the humanitarian parole program, but they did not ask for asylum in the U.S.
Well, if they did not ask for asylum in the U.S. and Canada won't get information that says that, they still need to have an anchor relative in Canada. And so if they didn't make a claim in the US, they get to go to a full refugee hearing. And once they're found eligible to make a refugee claim in Canada themselves, they can be an anchor relative for somebody else.
Would you advise someone right now who plan to go to Canada, about to ask for asylum in the US, not to do so? It would hurt them if they are certain they are going to move to Canada?
Yes, I do express caution about people making a refugee claim in the United States right now, especially if they're not a single person. Because doing that, if they later decide to come to Canada because they have a relative here, it cuts off anybody else they might be trying to approach the border with this fact of having made a claim in the US. Yes, absolutely. I'm glad you highlighted that question. Get advice. On the other hand, if they do not have an anchor relative here and they are fearing return to Haiti, but that's where we talk to a US lawyer about those rules and eligibility in the US.
We're about to finish, Kristin. I know I keep you for a very long time, but it was important to ask for some question. We have seen a lot of people turned away by Canada immigration system at the border. What changed? Was that because there was an elections or the policy has drastically changed as it was a couple of years ago?
Well, a couple of years ago, for sure, people were able to enter Canada prior to March 2023 through Roxham Road, and they didn't have to meet an exception to the Safe Third Country Agreement. So that really has changed. And it's hard. It does seem that I guess there are more people coming to the border, and there is greater scrutiny of people's documentation. I'm not aware of any policy or anything in writing that says look very closely, but that is the reality now. And it is the reality that the Customs and Border Protection is instructed to detain people who are sent back. So that is a kind of a definitive change. And then the practice and the discretion at the border is kind of always there. So never before, being prepared is the best way to
Yeah,
go.
we have seen, Christine, people who trying to cross, they go with almost every belongings they had on the US. Would that represent a problem for them? I know it's not a matter of law directly, but based on your experience, would that be a problem for someone trying, family of 4 or 5? They have
Right.
everybody has 4 or 5 luggage in their hands. Would that represent a problem for them?
It's a good question. I mean, it's not really a legal question, but I do get asked this question. I mean, if there is any other possibility that somebody else who can come and go across the border might be able to bring some of their belongings after the fact, that's probably ideal. Really, what happens at the border, though, is about looking at legal eligibility to seek protection in Canada. It's not the border officer's job to tell people they've brought too much luggage, but because you may be waiting a day or a day and a half, it's a lot of time to carry a lot of things. If there is another option that somebody can bring it for them, but really it's, my mandate and my focus is their legal documentation, not quite so much about what they bring. And maybe it makes sense to sell some things, but it's kind of outside of my realm. Yeah. It
Yeah.
shouldn't be a reason for refusal, Emmanuel. It's
Yeah.
it's more they need to look at the legal documents and the
I
eligibility.
see. But we also see agent they're asking people to disclose how much money they have. Would there any advice like say how much money should someone have, or would that hurt if someone doesn't have money or have too much when they are asked that question?
I don't have it at the tip of my head. I think there's some rule about not bringing more than $10,000 into between borders, but I don't have it clearly. I don't think that's a relevant question to be asked either. Once they get in, they might be asked that question. Well, they will be asked that question if they apply for legal aid, where they can get a lawyer, at least in Ontario. Um, but that also is kind of a little outside of the scope of my expertise, unfortunately.
I know you put some resources in Haitian Creole on your website,
Uh,
and it's very great. Can you tell us about like additional resources ever since we spoke last time that people can get if they go to their website and they would like to have it in Haitian Creole and French and like other languages?
Um, well, they have to go to the bottom of the website and there's a little button where you can press that gives you the option to change the language for our content. And we do have some links to other resources. So for once somebody is already inside Canada, how they can find a settlement organization or how they can prepare for their refugee hearing. So inside our website, we do include some links to other helpful resources. Is that what you meant?
Yes, and do you have other partners you work with? You can refer people in case like not every case you can take. Some other organization working closely with Canada Border Clinics.
Yes, we do. And we do have, uh, yes, sometimes we have had people who do have resources and they can't wait for the time for a consultation with us. And then we can give them, depending on where they're planning to cross and where they ultimately might want to live with their relative or nearby, we can provide them with names of lawyers that can assist them.
Is there anything, Christine, you would like to add? I didn't ask you, and you think it is very, very important for our viewers, like to know before they make the decision to cross the border.
Well, just to say that it's what was it my mother used to say? An ounce of prevention is better than a pound of cure. So it's better to work ahead and to gather all of your information. Work hard before you approach the border, because the consequences of being turned back and detained make it very difficult to try to challenge the decision, get you out of detention, and ask for reconsideration. So really, we are here to help. It may take a little while before we can give you a one-on-one consultation, but it's important to get somebody you trust or a legal opinion from somebody else about your documents and your eligibility to come to the border.
Thank you so much, Christy. It was a pleasure to have you with us, and thank you for taking the time more than you were allotted for us to answer our question. Thank you so much.
Well, thank you for this opportunity, Emmanuel. And, these are tough times. And so we really want to get the best information out there for people in sympathy and understanding for the hardships that people are facing. So thank you for this opportunity too.
Thank you so much for your time and consideration. It was Kristin Marshall with us from Canada Border Clinic, this organization helping immigrants who would like to cross the border, completing the process. Follow us on social media, on Facebook, YouTube, Twitter, and we also have our content available on Apple TV, on Roku, on Amazon Fire TV, and many other places. And you can also visit our website, ctninfo.com, where you can access all of our articles. Thank you so much for your time and consideration. It was Emmanuel Paul to serve you. We give you another appointment for another time for another interview. Thank you. Have a nice day.